all the general defenses, the wrongdoer can avoid the liability to compensate. So he can escape from paying compensation to the injured party. So these are the defenses, few defenses. First one is volenti-non-fit injuria, plaintiff the wrongdoer, where the plaintiff itself becomes the wrongdoer. Act of God, private defense, mistake, necessity, inevitable accident, and statutory authority. Let's discuss about the defenses that are available under tort in detail. First one is volenti-non-fit injuria. So according to volenti-non-fit injuria, the plaintiff agrees to suffer willfully with the full knowledge of the risk of the act, then the plaintiff will not be entitled to seek compensation from the wrongdoer or the defendant for the injury that he faces. So when the wrongdoer proves that the plaintiff has given such consent, he can avoid the compensation, then he would not be held liable by the court to compensate for the legal injuries that he has caused to the plaintiff. So in this case, if he proves that the plaintiff has given such consent, he would not be held liable. So the plaintiff also will not be entitled to seek or file a suit against the defendant for the compensation, as he has already given the consent by knowing the nature of the act that he is going to do, that it would cause such an injury. Then again, after doing that act and after causing such injury, he would not be entitled, or the plaintiff will not be entitled to seek compensation from the wrongdoer or the defendant. So this is known as volenti-non-fit injuria. Under this volenti-non-fit injuria, the name of the case law is Hall versus Brookland. The facts of the case are, during a car race at a Brookland, a car collided and it was flung into the spectators area, and Hall got injured due to that accident. Hall went and sued them. Who? Auto Racing Club. So Hall went and filed a suit in the court against the Brookland Auto Racing Club, asking for compensation. So the court held that Hall will not be entitled to get compensation or to seek compensation, as he has given his consent by knowing the nature of the act. So here Hall has given his consent by knowing the nature of the act he is going to do. He would not be entitled to seek compensation from the Auto Racing Club. And court also held that this was an accident which is considered as an extreme event, and the club was not held liable to pay compensation for the injuries caused to the Hall. Plaintiff the wrongdoer. So under this defense, the defendant, when he proves that the plaintiff, he himself is responsible for the legal injuries that he has suffered. So when the defendant proves that the damages caused to the plaintiff is due to the plaintiff's own fault, then only the defendant will be not held to compensate to the damages caused to the plaintiff. In this case, the plaintiff is injured due to his own wrong, and the defendant would not be held liable to compensate for the injuries caused to the plaintiff, because in this case the plaintiff is suffered from the legal injury due to his own fault, not by the defendant's action. The plaintiff is not entitled to seek compensation. Discuss about Act of God. So according to Act of God, it is a type of inevitable accident. So inevitable accident means impossible to prevent or stop from occurring an act or from occurring an event. So in this, the injury is incurred by natural forces which are extraordinary in nature and which cannot be anticipated. Here the injury is caused to the plaintiff due to the natural forces. Here the defendant does not have any part for causing the injury to plaintiff. So all the injury is caused to the plaintiff by the occurrence of natural forces. So in this situation, if the defendant proves that the injury caused to the plaintiff is due to the natural forces, then under this defense, the defendant will not be held liable to compensate to the legal injuries caused to the plaintiff. The private defense. Under this private defense, the defendant should use only reasonable force to protect a person or a property. Then only the defendant would not be held liable to pay compensation to the legal injuries caused to the plaintiff. So, for suppose if the defendant uses force beyond the reasonability, then obviously the defendant will be held liable to compensate to the injuries that are caused to the plaintiff. So here the important thing is the defendant should use reasonable force. Then only he will be not held to compensate to the injuries that he has caused to the plaintiff. Then only under this defense he will be not held liable tortiously. The next one is mistake. So if the defendant proves that the injury caused to the plaintiff was by a mistake, then the defendant obviously would not be held liable to compensate. Then in this scenario, if the defendant successfully proves that the injury caused to the plaintiff was by a mistake, then the plaintiff cannot claim or plaintiff would not be entitled to seek compensation from the defendant. So these are the defenses: private defense and mistake. Another defense known as necessity. The defense of necessity is applicable to the defendant when he proves that the act which caused damage was necessarily be done to prevent the greater harm. So if the defendant proves that the act which caused damage to the plaintiff was necessarily done to prevent the greater harm, then only the defendant will not be held liable to compensate to the damages that he has caused to the plaintiff. And if the defendant successfully proves that he has done the particular act to prevent a greater harm, then the defendant would not be held liable for the compensation to the injuries caused to the plaintiff. Discuss about the inevitable accident. This is also one of the defense that is available to the wrongdoer. So under this, if the defendant proves that in unavoidable situations the injuries were caused to the plaintiff. So under this defense, if the defendant successfully proves that the injury is caused to the plaintiff under an unavoidable situation, then the defendant would not be held liable to compensate to the plaintiff for the legal injuries caused to the plaintiff. And if the defendant successfully proves, the plaintiff cannot claim for the remedy in this scenario. The next one is statutory authority. According to this statutory authority, the defense of statutory authority is applicable to the defendant if the defendant proves that act causing the damage or injury is authorized by statutory authority. So consider an example. I have done an act that caused injury to another person. So the other person who has suffered from injury cannot claim because I have committed an act based on the instructions given by the statutory authority that I am working under. So under this scenario, if the act causes legal injury to any other person and if that act is instructed by the statutory authority, under this scenario the defendant would not be held liable for the legal injury caused to the plaintiff, and the plaintiff will not be entitled to seek compensation from the defendant as he has caused injury or acted according to the rules or the regulations or instructions given by the statutory authority.